In this lecture, I would be dwelling with the constitutional amendments, the Indian constitutional amendments, and the focus won't be on the technicalities as to what exactly are the wordings of those amendments, but whether these amendments really help in strengthening the Indian democracy, all the three democracies, that is the political democracy, the social democracy, as well as the economic democracy. So this is the broader framework under which we would be discussing the constitutional amendments, and I would be highlighting only those important amendments which has a relevance to our discussion. So that is the objective of the discussion today. If you look at the entire process of amendments which happened since the Constitution of India was enacted, you would find that the Constitution was amended many a times, and this amendment was also challenged many a times. The reason being that there was always a conflict as to what parts of the Constitution could be amended, whether the Constitution could be amended or not, and what is the basic structure of the Constitution. What important amendments were done to the Indian Constitution is what we are going to discuss, and whether those amendments really strengthened our political democracy, social democracy and economic democracy, or whether it weakened our democracy, that we would be looking in brief. So that is what is the introduction to it. The most important amendment, and which actually started the entire chain of amendments, is the first amendment of 1951. And this has a very interesting background, because you know that the Constitution, it took about 3 years of discussion, and debate amongst the Constitution makers, and it was thought to be the best document, and it would help the rulers to rule with social justice, political justice, and economic justice. However, when the states, the different states of India, they started talking about providing the social and economic justice to the people of India by attacking the zamindari system, especially the number of states like Uttar Pradesh, the provinces I would say, like Uttar Pradesh, Madhya Pradesh, Bihar, Madras, Assam, and Bombay. Okay, these were the provinces then. This was the era before the formation of states on the linguistic basis. So around 1949, when they started bringing in zamindari abolition bills, to the surprise of the constitution makers and Pandit Jawaharlal Nehru, the zamindar class, the class of the landowners, they started to take refuge in the constitution, and they started bringing in cases in the court which would start challenging the zamindari abolition bill. Okay, so mostly there was a consensus amongst the progressive leaders of Congress like Jawaharlal Nehru, G.B. Pant, and Sardar Patel, that zamindari abolition is necessary, and people who actually toil, they should be made the peasants, the farmers. That was the idea, and this idea also had the background of the increasing militancy on the land question. However, because the zamindar as a class, they started bringing in started going to the court and challenging the government that the right to property was being infringed upon by this Zamindari Abolition Act. Pandit Jawaharlal Nehru brought the First Amendment. Okay, so he moved the First Amendment in 1951 on 10th May 1951 and it was enacted by the Parliament on 18th June 1951. Okay, So this is very important understanding that the zamindars in various parts of the country challenge the constitutionality of the law permitting zamindari abolition, and the courts, for example, the Patna High Court upheld the landlords suit. Means the court started interpreting the constitution that yes, the landlords, the zamindars have the right to property. Okay, so in order to respond to that, the Congress government brought in this constitutional amendment, and this I feel that this amendment has to be looked at it from the perspective of strengthening the democracy of India. The reason being, the abolition of zamindari meant that about 20 million erstwhile tenants became the landowners. They became the farmers. Okay, so this, if you look at this data and if you look at the way it evolved, right? So the first amendment 1951, I should say that it was the progressive kind of amendment, okay, helped in strengthening the democracy. So what was that amendment? So it was, and the second point was also, right, in this amendment was to strengthen the social equality. What it said was, in this first amendment, nobody can interpret the Article 15 to deprive the socially and educationally backward classes from affirmative action or from giving them special provisions for their advancements. So this was the entire logic. So Article 15, you know that it prohibited the discrimination in the Indian Constitution, but it cannot be interpreted. That is what the amendment said. The clause was added, and this clause said that clause 4 was added, and it said that nothing in this article, that is Article 15, or even in the clause 2 of Article 29, shall prevent the government from making any special provision for the advancement of socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. So this is a very important amendment which was made and which clarified the Article 15. Okay, so discrimination does not include positive affirmative action. Okay, positive action or positive discrimination. Government can bring in special provisions for the advancement more backwards. Right. So this is how it has to be seen. The First Amendment. The second part, as I said, is the First Amendment inserted ninth schedule, and the ninth schedule now contains. So what was the ninth schedule? This ninth schedule was to contain the list of central and state laws which could not be challenged in the courts. Okay, as I said that the landowners challenged the land reforms. Okay, and because the Article 31 of the Constitution was the right to private ownership. Okay, so making use of the Article 31, the landowners challenged the land reforms, and hence the First Amendment, what it did was that it inserted all the zamindari abolition laws in the ninth schedule so that they would no longer be challenged by the court. Okay, so the main objective of the bill, the First Amendment bill, was, according to it, was to amend the Article 19 for the purposes indicated above, that is this above, and to insert provisions fully securing the constitutional validity of zamindari abolition law. So this has to be understood that why the ninth schedule was inserted, to prevent the government in acting on the behalf of common farmers and preventing the landlords to challenge this social justice movement. Okay, social and economic democracy strengthening initiative. The next amendment, which is an important amendment, is the 24th amendment, which was amended by Indira Gandhi government. And this actually has a background of who is more powerful. Okay, whether the legislature is more powerful, whether the executive is more powerful, or the court is more powerful. Okay, so there was a dispute, and the ruling of the Golaknath versus State of the Punjab case. In this judgment, the Supreme Court reversed the earlier judgment and it restricted the parliamentary powers to amend the constitution. And because Indira Gandhi was a powerful democratic leader, she didn't like that, and she wanted to ascertain the supremacy of the parliament. Okay, so in order to do that, what she did was that she modified the Article 368 by using the 24th Amendment, and she inserted clause 3, which said that the power of the parliament is now enhanced. Okay, and what was that power? To amend the constitution. Okay, so what it says is clearly that notwithstanding anything in the constitution, parliament may, in exercise of its constituent power, amend by the way of addition, variation, or repeal any provision of this constitution in accordance with the procedure laid down in the article. So irrespective of this technical wording, what it means is it wanted to increase the power of the parliament to amend the constitution. So that was the 24th Amendment, and I would say that it has to be looked at a mixed bag, because ultimately it has to be the elected representatives which are to be more powerful, because they are the ones who are elected and not the court. Okay, but some people would say that basically the court is interpreting the constitution, and constitution makers wanted to see that the basic framework of the constitution remains intact. Okay, so by increasing the power of the parliament to amend the constitution, this basic constitutional philosophy would also be challenged. Okay, so this could be looked at from both the perspective. However, the 42nd Amendment 1976, which is also ridiculed as a mini constitution, this was essentially the constitution which took away the political democracy of the people via bringing in emergency powers. So Indira Gandhi, you know that she brought in emergency, and that obviously is not that obviously was not a welcome development in the history of Indian democracy, and she used the power, her power, to amend the constitution to see that the emergency was imposed, and people could not challenge that emergency in the court. Okay, so that we should say that it was not a very progressive kind of stuff. She did include two words like secularism and socialism in the preamble to make sure that the government remains socialist and secular, but by assigning, by suspending the democracy and bringing in emergency, and also by prohibiting any activity as anti-national activity, especially 31D was brought in to prohibit any activity and calling it as anti-national and putting people behind the bars. We know that the entire opposition was behind the bars during her rule of emergency. So this amendment has to be clearly not to be considered as a positive development in strengthening the Indian democracy, especially the political democracy. She brought in fundamental duties to check the fundamental rights. She got the 368 article amended to keep it beyond, keep the emergency beyond the judicial review. Okay, and as I said, there was a prohibition of anti-national activities by bringing in the clause D in the Article 31. The 44th Amendment, which was by, you know that Indira Gandhi was defeated after emergency, and it was the Janata Party government which came into power, and it promised that whatever was lost as a way of the basic philosophy of constitution because of Indira Gandhi, that would be restored. The original constitution would be restored, and it would be the same constitution as was before emergency. That was a promise of Janata Party government. Shanta Bhushan was a law minister, and he actually reversed this mini constitution, and he brought in powers to limit this. He basically restricted the powers of the government to bring in emergency. So it said that emergency can be proclaimed only if there is a danger of armed rebellion and not just by internal disturbances, and it could be proclaimed only if there is a special majority, not by simple majority. So this was a major reform, I would say, to strengthen the power of the parliament and to prevent the executive from declaring emergency now and then. Okay. India had a very bad patch during the emergency era, and I guess that this kind of amendment was essential for strengthening the political democracy. Interestingly, the Janata government, because it was of a socialist lean, it challenged and it changed the right to property. It removed the right to property from the fundamental right list, and now, because of this amendment, 44th amendment 1976, right to property was no longer a fundamental right, but it was made a legal right. However, because it wanted the farmers to be assured that their land was intact, especially the people who cultivated their land, it said that the cultivators would get the necessary protection for the land ownership, provided the land was below the ceiling act, ceiling act of the respective state. So this was the 44th amendment. So the defining, the most important thing about this amendment, I would say, is challenging the right to property and converting the right to property to a legal right, and henceforth the right to property was no longer a fundamental right. The 73rd and 74th amendments strengthened the democracy, especially at the grassroots, because what it did was, it was essentially starting the elections at the Gram Panchayat level and at the municipality level. So a Panchayat Raj system was brought in by the 73rd amendment to strengthen the rural democracy, and the local bodies were strengthened by the 74th amendment of municipality. So these two amendments, I would say that they should be considered as strengthening the grassroots democracy, because they brought in many powers to the Panchayat Raj as well as the urban local bodies. And finally, I would say that this 86th amendment, which was passed in 2002, and it was as per our directive principles, is a very interesting and important amendment, because it made it inserted a new article 21A, and according to that article, the citizens of this country, they got the right to education, which is a very important right. So what does 21A say? This 21A says that the state shall provide free and compulsory education to all children of the age of 6 to 14 years. Okay, so that was what was promised, and the right, it was made a right. So earlier it was not a right. Up to 2002, the government was simply putting education into the directive principle that they wanted to educate, but it was not a right. From 2002 onwards, we as citizens can now go to the court and say that the government is not providing us free and compulsory education. Okay, so this actually has to be welcomed. Look at the wordings of the articles. The article 45 of the Constitution shall be substituted as enter. That is, provision for early childhood care and education to the children below the age of 6 years. So even the children below the 6 years were to be provided with early childhood care and education, and the state shall endeavor to provide early childhood care and education till the age of 6 years. So that is what the meaning is. So what it means is Article 45 and Article 21A, which were because of the 86th amendment, it strengthened the social democracy, because you know that education means empowerment, and by bringing in this amendment for the first time, though India is not the first country to give the right to education, in fact there are 150 plus countries who already had given this right. So we are pretty late in that, but it did convert the directive principle into a fundamental, into a constitutional right. Okay, so we need to look into the amendments which came in force after after the constitution was enacted since 1950, 26 January. Okay, as a mixed bag, wherein there was some compromise in the political democracy, especially during the Indira Gandhi regime, but other constitutional amendments did strengthen the political, social, and economic democracy. Thank you.